Alex here with part 138 of the My Docket series on child custody and visitation. As with my previous videos, I'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's a video that contains detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. We left off in part 137, if I remember correctly, with me submitting my reply to the court on the efforts I was undertaking to reduce my ex's arrearages to a judgment. If it wasn't the last video, it was the video before. This video goes into the sur-reply that the court ordered my ex's attorney to file. And that is, I think I've mentioned this before in one of my videos. I think it's the video Replies to Oppositions to Motion, that sometimes the court will decide to ignore new assertions raised on reply, and other times the court will decide to consider them but allow the other party an opportunity to respond to those new assertions in a sur-reply. And in this particular situation, this judge chose to allow my ex's attorney to respond to a very specific allegation on sur-reply. That allegation was that my ex waived her right to oppose me reducing the arrearages to a judgment because she didn't file I can't remember what kind of document, but she was supposed to file some kind of request for a hearing within 20 days of having received my letter, and she didn't do that, or at least that was my allegation. Of course, I'm here talking to you guys as, the owner of this channel, and yes, I did send that. And no, she didn't respond. And here is the ex's attorney's opportunity to actually respond to that sur-reply. So I think at this point in time, let's go ahead and take a look at what my ex's attorney has filed. Here we have my ex's attorney's sur-reply regarding dental expenses. Going into the first paragraph, looks like a standard introductory paragraph, which has my ex's name, her attorney, indicating that she's representing my ex and that she's filing a sur-reply regarding the dental expenses. Points and authorities. First, she states that her address is 6402, and this is old, guys, way old, years old. She's definitely not there anymore, and the reason I know this is because we tried to serve her there when we tried to terminate her parental rights. Otherwise, I would redact it. But yeah, she's not there anymore, hasn't been there in ages. My ex next asserts that she does not receive any mail at the address, and all mail should be posted to the P.O. box. I wonder if that's her actual address, or if she... So I'm trying to think back to when this occurred. I'm sure that I had a dispute or I confronted her on this address, but I can't remember any of the details, so maybe it'll come up later on in the case. Dental care. There is no question that our son's dental care that was in... Wait. There is no question that our son's dental care was care that was going to take place. The issues that are before the court are whether sufficient and timely communication regarding the treatment plan was made and how treatment was to be paid and why the community... Okay, so this is not what the judge asked her to do. The judge asked her to address a very specific statute. What is she doing? The parties together went to the initial... Okay, so why is she rehashing any of this? This is why... I mean, every time I go through one of these documents, it's like... It's so frustrating because I feel like this attorney just plays dumb. She just acts like she doesn't know what's going on, like a bewildered person. None of this is relevant. This is all stuff that we already discussed in briefing. So it's almost like she's trying to build herself up to justify violating the statute. That's what I'm seeing here. Already, I'm at line 14 of page 2, and I'm like, this lawyer has violated the statute, and she's trying to justify it by talking about all of these other things that we already talked about during briefing. Anyway, let's continue. Line 14. At that appointment, we were told that our son's teeth needed to be cleaned. She made it clear that her insurance at the time would not cover the extra cleaning, blah, blah, blah. The dental needs of our son were diagnosed and an estimate was prepared. It's obvious that I am taking the firm lead in scheduling appointments and consultations with giving my ex insufficient notice of the appointments. Oh, okay. I am very well aware of her situation at work and that she has to timely ask for time off. So, I mean, like, guys, this is like what I talk about in the videos. They will never say good things and win at all costs lawyering. I mean, even when they're back to the wall and they have nothing to say for themselves, they still do this where they try and say, hey, don't look at this issue here, Judge, that you told me to talk to you about. Look at all these other things that he's doing. He's a bad person. He's scheduling appointments. He's not giving me enough time. None of this stuff is true, but it doesn't matter that it's not true because it's a distraction from what the judge actually asked them to do, which is to discuss the statute. If any of you can't remember, just go back to the previous video or possibly the video prior. That's where you'll see the order from the judge saying, you know, Ms. Berning, I need you to respond with regards to this specific statute, which discusses why you didn't ask for a hearing within 20 days. They've spent an entire page not doing that. Let's look at the next page. My ex made it abundantly clear that she did not have the money to pay for the procedures. I insisted that my new wife had insurance cover. This isn't true either. And I filed affidavits. It's just bald-faced lie after bald-faced lie. Let's continue. I took it upon myself to make arrangements for the surgery without timely notifying. Okay, same thing. All during this time that my ex made it abundantly clear she could not have. Abundantly clear. That's the exact opposite of what the staff at the dental. You know, this is probably why they were so willing to testify on my behalf. Because she was even basically calling them liars. So could you imagine their perspective? They work at a dentist's office. A lady comes in, takes a seat, says she's going to pay for everything, signs documents, and then turns around and tells a judge that none of that was true. These people are like, what's going on? Is she like, does she have a memory issue? Because we were here. So anyway, you're going to see these people testify on the stand. I get two of them to testify. One is the dentist, one is the hygienist. And then we'll talk about it more when that happens. But let's continue. The bottom line is that my ex did not consent to treatment. I've already told you guys this is not relevant. You do not need a parent's consent to tax them costs on treatment. That's the law in Nevada. So the fact that she doesn't consent, which isn't even true in the first place, is not even relevant. Because this would just allow a parent to say, hey, I don't agree. And then just like that, you have to pay for all the costs of your medical care for your child. It doesn't work that way. You can say you don't agree all you want. You're still going to have to pay. That's the law. Next assertion here. As for whether just a bill is sufficient as proof of payment, that makes no sense, even though you said in... Hey, everyone. I mean, this is the perfect example of what you're going to have to deal with attorneys. Read this paragraph here. As to whether a bill is sufficient as proof of payment of anything, that makes no sense. And then go ahead and look at that prior hearing video, and you will see exactly where this attorney says the exact opposite as to what she is typing in here. So she will go into court and tell the judge to his face one thing, and then she will turn around and say the exact opposite thing, not even 1 month later, in the documents that she's filing. I mean, I've said before that attorneys are conniving, not all of them, but some of them. And in this particular case, this one is. And you can see examples just like this, multiple examples in this case of this happening. Let's go into the next section. I took it fully upon myself to govern and dictate. Okay, so now I'm a dictator. Anyway, all aspects of the dental treatment and procedure. This kind of hyperbole usually doesn't work on judges. I don't even know why lawyers do this. In the Supreme Court, it has no effect at all. In fact, if you do this, you look like a rookie. If you go into the Supreme Court and you file papers using this kind of hyperbole, you look like a newbie, like you don't know what you're doing, because it doesn't resonate with them at all. But anyway, in the lower court, I guess a lot of lawyers do this, and so they just kind of copy each other. I don't think it really works that well in the lower courts either. But I'm going to go ahead and continue. It rests firmly and completely on me to bear the responsibility of the cost of the treatment and procedure. Okay, guys. I've talked about this before in gender bias. I do not think any lawyer would ever dare say that the ex, which in this case would be a female, would have to pay the entire... I feel like this is something that has to be fueled by the fact that, oh, well, let's take advantage that he's a man. So let's go ahead and just throw this in there and just say that he has to pay for everything because it's not that big of a deal for him because he's a guy. If you want to know more about what I'm talking about, please watch my video, Gender Bias. Still, I don't think it's the worst bias that you're going to see in the court system. If you want to know what that is, watch the other video, Self-Representation Bias. Going into the next section. She says I misinterpret the law. Okay, so finally, at the bottom of page 3, she finally addresses the statute that the judge asked her to address. Here we go. So all the rest of this is nonsense. We're just now starting to deal with the court's order. The statute refers to an execution on a judgment. No, it doesn't. In this matter, we do not have a judgment. That's not true at all. Okay, so she's either trying to induce the court into committing an error, or she literally does not know how the law works. If you want to know more about how this law works, you can watch my video, Execution and Asset Seizure. Actually, I don't know if I think I do talk about that there. No, wait, it's probably under the 30-30 rule. Scratch that. Take a look at the video 30-30 rule. I think that's where I talk about this statute. Or maybe there's another video titled Reducing Arrearages to a Judgment. One of those two videos explains how this statute works. The judgment is already there. The child support order and the order to pay medical costs is what they call a judgment by operation of law. She should know that she's an attorney. So again, guys, I suspect that she does know this, and she's just saying this knowing that it's not true in the hopes that she can dupe the judge into actually believing her. But this statute does control, the plain language rule does control. If you want to know more about how the plain language rule works, you can watch my video, Statutory Construction. I didn't get to really bring this issue to the Supreme Court because I won. This is going to go to a hearing. The judge is going to side with me, and she's going to get dinged for the full amount of arrearages. So, and I guess that's better than winning on appeal. It's just winning outright. I'm going to go ahead and scroll into the next section here. She says, my interpretation of this other statute, subsection 7, is also flawed. There is an exception to equally sharing such expenses. It is found that extraordinary circumstances exist, and we do not have to share the expenses. Extraordinary circumstances exist in this case, so she says. The judge does not agree with this and will order her to pay. So again, guys, a lot of this is going to come home to roost when we get to the actual hearing video. Hang in there, because you will see that these arguments that this attorney is making are going to fall upon deaf ears. Going into the next section, certificate of mailing. She's indicating under Rule 5 that she has certified that this document was mailed to me. Next section here is declaration by my ex. She's swearing under penalty of perjury that all of the facts in this are asserted in this document are true and correct. Next section here is the index of exhibits. We have one exhibit, just 5 pages, and it's a bunch of emails. Let's take a look. Exhibit 1. Okay, so this is an email between, okay, so I already showed you guys this email. So all the lawyer did was, I'm assuming that all the lawyer did was just copy and staple these to the back. Is this? Yeah, these are emails between me and Kim Talati. So these for sure would have already been provided. So I'm going to go ahead and skip these guys because, as my policy is with the My Docket series, any documents that I've already gone over, I do not go over a second time. These documents I probably went over 3 or 4 motions ago. Yeah, this one for sure. These two for sure with my ex and I have already gone over. This one also. Okay, so this is duplicate stuff. Again, guys, these documents are located down in the description below. You can click on the link, download it, take a look for yourself. And if you have any questions, just post something down in the comments below. But all of these have been, covered already in the My Docket series. Request for submission. So I feel like I got these backwards. No, it's, I'm submitting my ex's Sur-Reply. Okay, well, I guess I can do that. That's odd that she didn't submit her own Sur-Reply. That's kind of what she would be expected to do. Anyway, Rule 5, Certificate of Service here, indicating that I served this request for submission upon my ex's attorney. If you guys want to know more about the request for submission, take a look at the video, Request for Submission. You can submit your opponent's documents to the court for a decision. There's nothing wrong with doing that. It's just really odd that she didn't do that. It makes me think she's playing games with the court system, and that by not submitting her Sur-Reply to the court for a decision, the court wouldn't know that it needed to make a decision. And that's kind of her way of trying to exploit some of the weaknesses in the procedure of the Second Judicial District Court to make it so that the court would never rule on this, which is what would have happened. I talk about that in the video, Request for Submission. If you don't file a request for submission, the court won't rule on it because the court won't even know that it's supposed to. So this is definitely shady that I had to do this for my ex's attorney. Very shady. Next, we have my objection to the Sur-Reply that was filed on February 13th, 2014. My objection here is that the court limited the scope of the Sur-Reply, which is normal for Sur-Replies. That's the point of a Sur-Reply, is to just address the very specific issues that were raised in a reply, to not go ahead and go in and open up all these other things for the court to consider. So I'm objecting here to all of the other issues that my ex's attorney raised in that Sur-Reply, and I want the court to not consider them. That's what I'm doing with this objection that I filed. Next page, we have Rule 5, Certificate of Service, indicating that I served this objection to my ex's attorney. Next document. Actually, let's go over this document here first. So the request for submission, again, this is me and it looks like I am submitting to the court my motion to compel the disclosure of physical addresses. So this is probably just a document that was just hanging out, guys, that just never got submitted. I don't know, or maybe it did get submitted and I just didn't get to it in one of the previous videos. But it's just one of those extra requests for submissions that needed to be filed to submit something to the court for a decision. In this particular case, it's the motion to compel. And I know that this has been addressed in the sur-reply. So, I mean, that's really awkward in and of itself. She should be addressing this by opposition. Okay, it's just getting really weird now as to how the attorney is responding to the documents, but she can do those things, I guess. Again, same thing, guys. If you want to learn more about requests for submission, you can watch my video on the topic. And we have Rule 5 Certificate of Service indicating that I served this document to my ex's attorney. And now we can go to that other document, which is the Certificate of Clerk and Transmittal. I think what happened here is that the clerk transmitted the order denying my request to proceed in form of paupers to the Supreme Court of Nevada. We've already talked about this in the video where I went over the Supreme Court filing, so we don't really need to talk about it anymore. This is just a document that's entered by the clerk transmitting that order to the Supreme Court. Going into the aftermath, I filed, let's see, 2 requests for submissions and an objection, so that's 3 documents. My ex's attorney filed 1 document. My documents were free filing, so I incurred $0 in costs. My ex's attorney's also was a free filing, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex's attorney would have probably spent, I suppose, an hour on that sur-reply, especially given all that extra stuff that she included. It could have been 45 minutes, but you know what? Let's make it an hour if we round in the review of all the other documents that were filed. So both requests for submissions and the objection that I filed. I think an hour for all of that is reasonable. That at the rate of $250 $250 an hour for my attorney comes to an amount of $250 for my ex in attorney fees. As in my previous videos, if you have any questions, feel free to mention those questions down in the comments below, and I will see you guys next time.